So my talk today is going to be about shadow banning. The word was already mentioned a few times yesterday. So I really enjoyed the discussion yesterday, and I thank you all for providing such a perfect kind of segue for me to talk about this concept. Also to Jules for laying the groundwork on the Digital Services Act, because I'm going to be combining those topics. The basic question I'm interested in is what the Digital Services Act will mean for this phenomenon of shadow banning. And the image you see here is a tweet from Elon Musk, someone who I prefer to avoid, but I feel like I cannot in this context, because he tweeted last week about shadow banning, or a few weeks ago rather, with this, I think, rather evocative image of the Shadow Ban Council, which allegedly was reviewing all his tweets. So I think this image really encapsulates a lot of the imaginary around this term, which I agree with Tarleton, as you mentioned yesterday, is subject to many different interpretations, but it tends to have this conspiratorial note to it, of this opaque cabal that is governing all our online fates. Today, I'm going to talk about what is shadow banning. So what do we mean by this concept, and try to unpack a little bit some of the conflicting interpretations that it is subject to. And then I'm going to talk about the Digital Services Act and dive into its transparency obligations related to content moderation and how they will end up regulating shadow banning, or might end up doing so. Part 3 is where we entered into the more half-baked territory, where I will unpack what I think is the most significant question that also the Digital Services Act raises, which is how we conceive of transparency rights in the context of visibility remedies or demotion. So I guess that's also in line with a lot of things that Tarleton said yesterday. I see that there's the concept of shadow banning necessitates that we engage with this question of what is content moderation and how does that work in the context of ranking or visibility remedies. So I'll start with part 1, what is shadow banning? I think a minimal definition of the concept, which like the core meaning that seems to be referred to in almost every usage, is that of a content moderation action that is carried out in secret. I think a relevant distinction is that it tends to speak to the transparency of outputs rather than reasons or logics. That is to say, the salient issue with shadow banning tends to be not why was a piece of content actioned or sanctioned, but simply has it been sanctioned or not? What items are being sanctioned? So in this sense, it speaks to outputs rather than algorithmic logics per se, is how I would interpret it. And one of the core claims I make in terms of its current usage is that it's shifting. And I identify a original narrow meaning of this term and a current broader meaning. So the original usage of shadow banning, which is really quite old, originates in bulletin boards and web forums, where it tended to refer specifically to account suspension measures. And the idea was that people would be given the impression that they were still able to use their account and post content, whereas in fact it wasn't accessible to anyone but themselves. So it was really a deceptive measure with active concealment. There's now, but in the current broader meaning, it refers to a far broader suite of content moderation measures, which include demonetization. But in particular, I argue that most current debates about shadow banning revolve around visibility remedies. And in a bit, I'll try to unpack some of the reasons for that. I think it's important to note that, as implied here, that shadow banning should be understood as an exponent of the design of different remedies. So the design of remedies matters very much for the phenomenon of shadow banning. And I say this in opposition to some legal perspectives, which tend to focus only on what we reflexively define as transparency policies, right? So they focus only on whether a measure is disclosed and not on how a measure is designed in terms of how it can be observed by actors. And I think bringing that kind of design perspective in is very important. And I draw on a lot of the recent empirical work that has been done on shadow banning to that end, and user experiences of shadow banning. And what I do is that I review these different content moderation remedies and see to what extent users are able to detect the presence of these remedies as they affect them. I'll start with account suspension. Unfortunately, that's actually the remedy which I see the least literature on. So this is the more, I've had to do this, come up with this a bit more myself. But my basic claim is that account suspension is a measure that doesn't really afford effective secrecy. As I mentioned, the prototypical kind of narrow definition of shadow banning implies a deliberate concealment where you're showing the suspended user a different version of the service than what you're presenting to others. However, there are very important limits to this kind of strategy, it seems, in terms of keeping the suspension secret, which is that, first of all, most of these concealment measures can be circumvented, depending on whether it's IP-based or account-based. You can typically, log out and see whether your content is still visible, or change your IP address, or simply ask a third party like a friend to see whether your content is visible. More importantly, though, I think, is that even when the decision is concealed, suspension is self-evident in its effects. That is to say, what you can't fake is engagement. And if you suspend an account and hide all its content, you will inevitably cut off all engagement by other users. So I would say that all but the least popular users are very likely to start noticing that something is amiss. So these are the reasons why I would argue that account suspension, compared to some other measures we'll discuss now, doesn't afford particularly effective secrecy and is not central for those reasons to modern concerns about shadow banning. I'll talk a bit about demonetization. This was interesting to me because demonetization was a measure which initially I assumed would be relatively self-evident and would not be relevant to shadow banning concerns, because my baseline assumption was, well, you can't fake payments, right? So if you can, you might fake someone's account activity to give them the impression that their account is still active, but you can't fake paying someone monetization revenues, right? But there's this very interesting study by Robin Kaplan and Tarleton Gillespie on YouTube's demonetization, which also talks to user experiences of this policy. And they show that until YouTube instituted an explicit notification policy, that demonetization was often very difficult for users to detect. And that's, I would say, basically due to the volatile revenue streams of YouTubers and the non-granular accounting of their revenues. So, most YouTubers would be uploading many videos, monetizing many videos. And if one of them were to be demonetized, that would not necessarily lead to a noticeable impact on the revenue streams. And even if it did, you would not necessarily be able to identify which of those videos had been demonetized. So this was an interesting learning process, at least for me, to realize that what to me initially seemed as a rather self-evident measure was often anything but. And it highlights again the significance of disclosure in these contexts. However, what I see in the literature on the recent literature on shadow banning is that most concerns are about visibility remedies. So I'm using that to refer here to demotion primarily and delisting, which are, of course, very closely connected concepts. So there's been a lot of recent research into these phenomena, which typically shows that this is a very common concern amongst users, that they perceive, kind of like Elon Musk, that there might be this shadowy cabal interfering with their visibility in secret ways. And those kinds of concerns are typically triggered by declines in audience engagement or visibility, right? But then the essential question which every user faces is this indeed the shadowy cabal? Is this what you might call top-down content moderation? Or can alternative explanations be found? And so this is the constant back and forth you see in these shadow banning discourses, is that the alternative explanations are more structural and user-driven. Simply, your content is not engaging users anymore, or maybe other competitors are engaging users better, or perhaps the algorithm has changed in a more systemic way. So there's been a restructuring of how relevance or engagement is constructed, for instance. Frank Pasquale, I think memory describes being swept up in a broader algorithmic shakeup, right? And so this is then typically used as a counterexample to shadow banning. And I think that this discourse speaks to some of the uncertainty of the term, right? When is a decline in ranking a form of content moderation, and when is it simply a structural result of what we might call the routine of curation? That's a question I'll get back to in a minute. But I guess what you guys might be most interested in is the EU Digital Services Act. So I'll discuss that first. So running with the Elon Musk theme, you know, if he's concerned about shadow banning, then it'll be interesting to see what Thierry Breton, the commissioner, EU commissioner responsible for the Digital Services Act, is going to do with this topic. So just to do some throat clearing here, I can rely thankfully on much of what Joris has already done to assume that you are familiar with the basics of what the Digital Services Act is trying to do. I would summarize it as follows, in that, building also on the work of Eric Goldman, the legal approaches to content moderation have historically focused on what I would call takedown measures, and what he calls a binary leave up or takedown paradigm, where the law is mostly interested in, is something left up or is it taken down? And that's really the only salient question in terms of rights and obligations. And takedown here for me means account suspension or content removal, or also geoblocking. So this is this binary paradigm. And of course, corollaries of this paradigm are that it's primarily interested in unlawful content, because if something is unlawful, then typically the remedy is to cease its publication, right? i.e. to take it down. And this is reflected in older laws like the Digital Millennium Copyright Act, which has a notice and takedown framework. Also in more recent efforts like the German NetzDG is also about takedown and the enforcement of liabilities. And what the DSA is doing is far broader than this and starts to encompass and regulate many of these alternative remedies. So I emphasize that these are pluses, not ors, right? So it also does regulate unlawful content and all of what the binary paradigm entails, but it adds new perspectives and dimensions to it. So in addition to unlawful content, it is interested in lawful content and how that is regulated through the platform's terms of service and how those rules are enforced. In addition to the construct of publication, it is interested in how an amplification and when platforms might be responsible for amplifying or creating visibility through their recommender systems for content. And corollary to that is that the frame shifts from strict liabilities to broader systemic risks and responsibilities. In legal terms, this means that the framework developed in the DSA is not a notice and takedown framework, but a notice and action framework. Because the content isn't necessarily unlawful, it doesn't necessarily need to be removed either, and other remedies might be more appropriate. And this is why the Digital Services Act is far more interested in these other measures such as downranking and delisting, disclaimers and labels, or indeed demonetization. I think Joris already cited for you the definition of content moderation, so you can take it from me rather than reading through all of this, that it does include non-takedown measures. So it explicitly includes measures that affect the availability, visibility, and accessibility of that content. Now, what does the DSA do in terms of transparency rights, and how does that interact with shadow banning? The first article I would highlight is Article 12, which is about terms and conditions. And I would refer to this as the codification provision. In short, what it requires is that all the terms of service restrictions that platforms have must be codified in a systematic way. So the key phrases here is that any restrictions they impose in relation to the use of their service in respect of information provided by recipients of the service. So in other words, restrictions imposed in relation to the use of their service regarding user-generated content. And they need to specify any policies, procedures, measures, and tools used for the purposes of content moderation. And as we know from the definition, content moderation here is understood in this broad sense. So yes, including visibility remedies. What does this mean for shadow banning? I think it's perhaps a first pass at clarifying some of the issues here, but of course, how should I put this? Terms and conditions only clarify the policies in the abstract, right? And so in some sense, they speak to the reasons or the justifications that platforms give for their decisions, but they don't provide clarity into the actual decisions being taken, right? So it might allow users to self-assess to some degree. Might I be violating this or that policy, which could incur a downranking or visibility restriction? But as we all know, there are, of course, big discrepancies between how platforms formulate their policies in aspirational terms and how those end up being operationalized and enforced in practice, right? So I think this will only provide in itself a minimal reassurance to users. And for that reason, the far more important provision is not Article 12, but Article 15, which is precisely about notifying users about individual decisions. This is what the DSA calls a statement of reasons. So the core language here is that where a provider of hosting services decides to remove or disable access to specific items information, it shall inform the recipient and provide a clear and specific statement of reasons for that decision. So the observing reader will have noticed, of course, that this suddenly drops this broad understanding of content moderation and it narrows it only to decisions to remove or disable. When I first read this was really surprising to me, precisely because, based on the critique I've just outlined, it's these alternative remedies that are in fact far less transparent and far more in need of these kind of notices to become visible to users. So how ironic and how misplaced that then the notice obligation would only apply to the relatively self-evident suspension or removal decisions. So what's going on here? Interestingly, though, the language I'm now quoting is from the original proposal from the European Commission. And since then, there have been amendments tabled by the other parties in this legislative procedure, the Parliament and the Council, which have tried to expand it, which have tried to pick up on this critique, which, as an aside, was a problem for my writing process because I effectively got scooped by the legislator. The first version of this paper was entirely about critiquing this original proposal. But of course, it's nice to see that the legislator shares my concerns. So here's the amendment from the European Parliament on this issue. And they expand it, right? So I've highlighted the relevant amendments. The first is that it's not just decisions to remove or disable access which need to be explained to the user, but also to demote or to impose other measures. So with this variant, it seems that Article 15 would come close to perhaps, at least on paper, a prohibition of shadow banning. Any demotion decision or indeed any other content moderation measure decision based on this broad definition would have to be notified. The caveat here, which the Parliament also includes, is they also include an exception, which I'm not sure if you can read because it's at the bottom of the screen, but they say that this obligation, so this obligation to notify users of decisions, shall not apply where the content is deceptive, high volume commercial content. So that's actually an entirely new concept in EU law. It's a phrasing that's never been used before, deceptive, high volume commercial content. It seems obviously to be directed at spam, right? And so indirectly, I think it seems to be concerned with circumvention or adversarial actors, right? And that in those cases, secrecy might be justified. I'm afraid the second half of this quote has been cut off in the slide, but there is a second clause to this sentence. So the first is an exception for spam, and the second is an exception where secrecy has been demanded by a judicial or law enforcement body in connection with a criminal investigation, right? So there might be instances in which content moderation decisions are prompted by criminal investigations, and in those cases, the police might demand secrecy in order to keep that investigation under wraps. So, in short, this amended version would expand the notice right towards alternative remedies and demotion in particular, but it would also include exceptions, which would help manage cases of adversarial spam, commercial spam, as well as criminal investigation. Now, of course, we can have many debates about interpreting these rules. Are they adequate? But precisely because the final version has not been finalized, I'm going to leave that for now. I'm going to bracket these. Like, you can split hairs about whether deceptive high volume content is a useful concept or not, but since the final text of the proposal hasn't been decided on, I'm going to leave that for now. This is an overview of the relevant language we just saw, so I'll skip that. The part I want to focus on in my remaining time is, the half-baked part, which is my concern about how we start to operationalize and enforce transparency rights in demotion, right? If we conclude that the key issue for the regulation of shadow banning is transparency rights, notice rights as regards demotion and other visibility remedies, we need to start developing a legal concept for demotion, which, as far as I'm aware of, hasn't really started to happen yet. And I think it raises very difficult and fundamental questions about what content moderation is and how we distinguish it from content curation in a more general sense. So, as I said, this is a little bit half-baked, so the argument is not entirely settled yet, but I feel like this relates to a point that's been made already in the discussion yesterday, which is when you try to delineate demotion decisions, you face this baseline problem, or what's also been called a counterfactual problem, which is, what is the default treatment, right? Precisely because ranking is this zero-sum process, and also you might say a subjective process. When we conclude, thank you, 10 minutes, when we conclude that there's a decline in ranking, it begs the question, what would the ordinary or the default ranking be? I think this might be done, but to do so requires a detailed engagement with the specific ranking architectures of these systems. And I don't want to understate the technical complexity that raises. And I think one of the main questions is whether regulators will ever be up to that task. And, I hope that also speaks to the theme of this conference, which is, I think, I notice myself that I encounter the limits of my own technical expertise in these discussions. And I think this is one of these areas where lawyers are going to become very much dependent on technical expertise, which will either be provided by, sophisticated regulators or by the platforms themselves. And so we'll have to see how that debate pans out. I try to engage with the descriptions that platforms offer of their own ranking systems and to see what demotion might look like in a legal sense within those systems. So here's one of Facebook's own presentations of their ranking flow, which, as many commentators have observed, is not one. It can be conceived of as one flow or algorithm, but also entails all these subsystems and separate sub-algorithms, you might say. And the way they describe it is that there's a first step of an inventory where they collect all the relevant candidates. Then there is the assessment of relevance based on their relevance constructs in which they assign scores to content. And then in a more or less ex post way, there are separate subsystems, which they call integrity processes, which test for, you might say, content moderation related principles, such as borderline content or fact checking. And these then impose a kind of ex post malice, which cannot be operationalized in different ways on the ranking scores that have been done in this relevance scoring process. So I would propose that, although I don't want to underestimate the technical complexities of this, that when a right like the one we see in DSA will be introduced, probably regulators will try to engage with systems like this and try to delineate which of these subsystems they consider to be some type of content moderation. But I also want to highlight the kind of limits of this ambition, which speaks to the ways in which platforms exercise power in ranking, not just in that kind of restrictive scope of the integrity processes, but throughout all these other steps of the process in their inventory and their ranking relevance scores, etc. And then you start to see ranking not just as a relatively narrow issue of content moderation, but a broader practice of content curation. I think one pithy way of putting this is that platforms don't just reduce visibility, they construct visibility, right? And there's been quite a lot of work here. Again, I'm quoting Charlton all the time. That these constructs like relevance or quality or engagement that platforms are measuring for are in how they're operationalized and constantly revised and updated entail their own politics, which are not objective or neutral, but always subjective and value laden. So I have a picture here of I use the example also in the paper of the controversy around Facebook's engagement systems, where they expanded from likes to many other engagement metrics and were subsequently accused by measuring angry emojis as engagement, as a prominent form of engagement, of surfacing negative and polarizing content. And so the ultimate solution by Facebook was to continue to allow people to engage with angry reacts, but no longer to measure them as a form of engagement. So I think that example quite well shows the kind of politically contingent nature of these concepts like relevance or engagement, and how these are kind of iteratively based on observed correlations, adjusted and adapted by the platforms in service of their business interests. And it's this kind of, I would say, constitutive aspect of constructing content relevance or curation, which, if you focus narrowly on individual rights, gets left out. So I think this broader view of ranking as curation poses several problems for this individual due process model, which is implicit in the DSA and we might say in the shadow banning imaginary itself. This is indeed, again, that baseline problem I talked about. Can the law distinguish meaningfully between moderation as an exceptional sanction and curation as a routine or default expectation? Secondly, how will these definitions normalize other aspects of ranking curation and ranking governance? And once we've established some rules for demotion transparency, what kind of alternative transparency models might be needed or useful to capture these other dimensions of ranking power? So I think I'm towards the end of my time here. I'll just wrap up with some key takeaways of what I've been trying to argue. It's that, first of all, I've argued that shadow banning, I think, needs to be understood not in the narrow way that sometimes platforms or others try to define it as a account suspension measure, but in a far broader sense as speaking to all secret remedies, and in particular, visibility remedies such as emotion, because these are the remedies that are in practice the most difficult for users to observe. We've looked at the DSA, and I think it's still an open question whether it will prohibit shadow banning. So keep in mind that the amendments I've showed you haven't been confirmed yet. And so, in fact, the DSA's legislative process reflects a really interesting debate or negotiation for legislators trying to define what content moderation is and where their due process model begins and ends. If something like the current version is implemented, the main interpretational issues will be the interpretation, formulation of exceptions. So these exceptions for spam or law enforcement or perhaps other ones that we haven't seen yet that might be included, as well as the implication of what, as we've discussed, constitutes content moderation at all and how it extends into practices like ranking. And the final, still, I would say, half-baked point is that I would say that both the shadow banning imaginary and the DSA's due process framework both rest on this unstable concept of content moderation, which breaks down, especially in the context of content ranking and curation. That's it for now. So I look forward to your questions and thank you for your time.
Thank you, Paddy. We have some questions here in the room, and if anyone has a question online, you can say so in the chat or raise your hand online. So, Amy?
Thanks, Paddy. That's really interesting. I shadow ban people on a regular basis. Hello, my name is Amy, and I shadow ban people. And I want to tell you why. The reason we regularly shadow ban people on our science is because people who are banned for flagrant violations of rules just come back with a new account over and over and over. And we get a little bit of relief from the onslaught by if they don't realize they've been banned this time. So my conclusion about this is I do think transparency is better, but there are all kinds of places where transparency just doesn't work for content moderation. I think what we need is a better solution to the problem of online identity. And if we could reliably know who is sending this content, then we could just tell the person, look, you've broken our rules, you've posted racist stuff 4 times, we're done with you, goodbye. And if they couldn't come back with another account, then we'd just tell them, right? So I think it's important in understanding this phenomena to understand why people use it.
Yeah, thank you. That's such an interesting example. It speaks to something that perhaps a lack of nuance in one of my points already, which is that I've been talking about account suspensions as a form of shadow banning, and with the expectation that it's typically self-evident to users. But this is, I guess, based on the implicit model that it's a service-wide suspension, right? So your entire Reddit account is shadow banned or something. But I guess it's precisely in these concepts like specific subreddits where I can imagine it might be less obvious to the user. If you're active on many different subreddits and it's only one where your content isn't being engaged with, it becomes a more subtle measure. So let me just state that first of all. I think that's a really interesting example, which might lead me to revisit some of my arguments. But I take your comment as speaking also to some of the normative dimensions of why transparency matters and why secrecy matters in content moderation, which is something I've kind of deliberately dodged in this presentation because it's another can of worms. I do try to get into it in the paper as well. And yeah, I think it's important to recognize that there are trade-offs here, and several of them. One thing I'd point out is that currently, so there's a narrow, I would say, technocratic argument in favor of secrecy, which is about circumvention by adversarial actors, right? But there's also broader reasons why platforms might prefer shadow banning or be disinterested in disclosure, which have to do with more cynical motives like concerns for their reputation or for political or legal risk, right? So, and the problem in the current situation is that platforms are not required to distinguish between them, and they're never forced to really stake their claims. But it's a big tension that's coming up with the Digital Services Act. You know, we see these exceptions that are proposed, but they're really quite narrowly construed, these exceptions, right? And it remains to be seen how, because in effect, the DSA's due process model is irreconcilable with the kind of adversarial or security-based model that most content moderators have. But I think the first step will be having platforms stake their claims a bit more specifically. So, because of course, not all actors are adversarial, right? And so in which cases is justified and in which cases is it not?
Thank you. Tarleton has a question online. Tarleton, can you unmute and ask your question?
Yeah, I think so. Can you hear me?
Yes.
Yeah, thanks so much. I'm sorry I couldn't join you all for the second day. Paddy, really terrific presentation and lots for us to think about together. I wonder, as a specific question, I think I know the answer. As the amendment process that you were talking about is happening, where they're maybe adding demotion into that kind of reporting requirement, do you think there's anyone there that is thinking about the part that you're thinking about, like what it would mean to make demotion transparent? Or is it just like, oh no, we left that thing that we included in the definition earlier out of this piece? Is it simply just kind of like fixing the continuity, or is there any place where that discussion might be happening among the process? Yeah,
sorry to interrupt. Yeah, I think that's a really, really good question and one I've been wondering about myself. So when I saw the original draft from the commission, people had conflicting theories. So I saw this as a huge inconsistency. Others thought it was probably just an accidental omission. Perhaps the commission hasn't understood the full nuances of shadow banning and the significance of the scope of this notice right. But my theory why it's deliberate is twofold, is because throughout the DSA, there's this very broad understanding of content moderation. So almost every other right does include all these other things. So it's conspicuous in that it diverts from this kind of baseline of broad understanding of content moderation. And the other one, which I think is really confirms that theory, is that there's only one other provision that is similarly narrow, and that's the appeals right. So when you get to appeal, it's also, at least in the original draft, limited to takedown decisions.
Wow, that's interesting.
So I think there's the idea that individual due process is limited to the kind of severe issues, the most far-reaching measures that then might also trigger like putback obligations or something like this. And we're definitely not at the point where we say like reprioritization as like the demotion corollary to.
Right.
Yeah. So I think that's an important part. And however, I do know that the platforms have been very alert to this issue. So before revealing my own personal interest in the topic, I asked someone from Google, what their interest was in the DSA, and they said Article 15. So I'm sure some people are aware of it.
Yeah, cool. Thank you.
All right, David Carger from MIT. So first, a little thing I just wanted to pick up on at the end of your talk when you talked about the difficulty of defining demotion. I mean, as a technician, it seems to me that if it becomes illegal for me to demote content, I can rewrite all my code so that all the content is promoted. It's just that some of it is promoted less. And I don't see a way around that sort of definitionally. But what I really wanted to get your thoughts on was a more complicated question of this whole idea of objecting to shadow banning or objecting to demotion suggests that some rights are being violated somewhere. And I'm wondering what right it is. That is, I don't think that I have a right to have the platforms amplify what I'm saying, right? Or spread it to anybody in particular. I think that a common perspective of the platforms is that they are, in theory, although not in practice, giving every person what they want to see. And so if I build that platform that gives every person what they want to see, and it doesn't give anybody your content, right? Am I shadow banning you? Or am I just fulfilling the goals of the users of my platform and sort of doing exactly what they want? Does shadow banning mean that, it has to be about something that the recipient wants to receive and I'm interfering with the reception? Is it really about the right of the receiver to see what somebody is saying as opposed to the right of the speaker to say something? Just some things I'm puzzled about.
Thank you. These are very good questions, and I think also tie into some of what was just raised by the others, in the sense that I would agree that like what you see also in the Commission's original proposal is that you should have transparency and specific notice and explanation for those decisions which you might have legal rights to contest. And you might vindicate those rights if you better explain those decisions, right? And so the DSA does say that in certain cases, platforms legally cannot suspend you and they cannot remove your content. And then because you have that right in place, transparency is necessary to enforce that right. But indeed, like you say, there is no positive right for users to be recommended, right? And so within that reasoning, which is essentially a due process reasoning, which due process is typically conceived of by lawyers as permitting procedures for the vindication of legal entitlements or rights. Within that due process framework, it doesn't necessarily make sense to say you need to explain it even though you don't really have a right to contest it, although that might be where the DSA is now headed. I think you can also develop other theories, though, as to why it matters. So let me think about this. There is, of course, an argument that when you downrank or demote, you are not giving users, showing users what they want to see, right? But then that implies that demotion is a departure from the objective or naturalized relevance construction, right? So we have a relevance score, which implies that you ought to have been shown in this way, but then the borderline content policy was triggered, and then I was deprived of that objective rank. But that's kind of what I'm trying to articulate as well, is that when you define demotion in that way, you're doing it by reifying or naturalizing the platform's, I would say, politically subjective ideas of what relevance is, right? Well, I guess I won't belabor that point much more. I do think the other point you raised about that you could redefine every malice as a bonus for everyone else, indirectly targeted. I think that's very relevant and speaks to a typical concern in transparency literature more broadly, which is often referred to as the shifting locus of decision making, right? So if you enforce that meetings are public, then people will have separate sessions behind closed doors to really hash out their differences, right? And if you demand that this aspect of a corporation is disclosed, then the action shifts to another team in the corporation, right? And it's I would say that here we see within these algorithmic systems and subsystems a similar version of that. You say to the platform, disclose and explain everything about this part of your algorithm, and then you just move the action to a different part. So it's precisely because these algorithms are so dynamic and you can't really pin them down, as some people say, that I think enforcing this is going to be very, very, very difficult.
Thanks, Paddy. Yeah, sorry. I'll be quick. Thanks, Paddy. Gavin Sullivan from Edinburgh Law School. I just wonder if you could go into a little bit more detail about Article 15 and where you think this is going. I mean, I work in the area of sanctions law, and when I read about statement of reasons being provided for due process, we have, of course, years of jurisprudence in the EU about what that means, largely stemming through the controversies in the Cardi case. And I'm just wondering whether or not you see that that's the direction of travel here in terms of where this statement of reasons go. How far do you think these provisions will be pushed in practice? Will it push, because in the sanctions context, of course, it was about providing enough information to people so that they could adequately challenge the decisions and defend themselves in those contexts. And if you put that into the content moderation context that you described there, potentially that could go a long way in terms of what platforms would have to provide to those who are affected by any number of the content moderation processes. Is that where this is likely to go? And I guess the second kind of sub-part of that question is, if so, is that going to be pushing the internal complaint redress mechanisms that platforms are providing into much closer alignment with what individuals can expect in judicial remedies currently before the courts?
Thank you. Yeah, you're touching on an entirely different complexity of Article 15, which I've tried to kind of hide from you guys, which is it's called a statement of reasons, right? I have focused basically on what I would call bare notice, in line with this definition of shadow banning as an issue of outputs rather than reasons or logics, whether you've been actioned or not. I'm interested in the minimal question of should anything be notified to the user. But Article 15 demands much more than that. It doesn't just demand notifying the user you have been sanctioned or this content has been sanctioned, but these are the reasons for it. So this is the policy you have violated. These are the factual circumstances that led to this decision. So in terms of its implementation and interpretation, this is where it becomes tremendously more complex, especially, of course, with these algorithmic enforcement systems where pinning down reasons is, of course, the entire problem of explainability. So how we can start to interpret that is very, very difficult. I have to say I'm not as familiar with the kind of public law precedents for statements of reasons, although, of course, this is like for the non-lawyers, a very basic principle of good administration or public due process, which is in almost all government decision-making, there is a precedent for this. So inevitably, there will be some reasoning based on analogies to those public administration precedents, certainly. If we do look at these due process precedent. One final point I'll make is that, which ties back into the first comment, which was made by Amy, is that not notifying sanctions is reserved for the most exceptional cases, typically in ongoing surveillance and law enforcement. That is like one of the main areas where secret sanctions by government are permitted at all, right? And so this, by analogy, you see a similar reasoning from platforms, right? We have transparency for some users, but some threats are so adversarial and significant that we need to have secrecy to effectively carry out our duties. So it's like implicitly, you could appeal to this analogy to anti-terrorism. One interesting best practice from that field is ex post notification, right? So that's what you see in like European Court of Human Rights case law on anti-terrorism and police surveillance. It's the conclusion that, well, you may not have to notify people that they're being surveilled as it's happening, but once the investigation is concluded, then they should know. So that at some point, accountability can be rendered for these powers. Long story short, I think there's very much we can learn by analogy to states, although of course there will be many differences as well. I think that's going to be a really ripe field for discussion.
Okay, great. Thank you again, Paddy.